Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will
relevant.
bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
We're getting commentary on the case. Dati mihi Anglican, please, service Latino.
Is that correct?
Literally not true.
I didn't ask you to interrupt me. Oh, for Trump's sake.
Welcome back to the Court of Public Opinion. I am the Recovery Addict. Still just as sleepy as I was this morning. Have not had a nap. But I did have some delicious, like a soft-shelled taco, I guess. My wife went to the store the other day, yesterday, so this is leftovers. And she got one of those big, long, it's in the deli section. It's got the little stack of tortillas and like the cheese and all the fixins and little sauce and everything. I got that. Chicken tortilla. I don't know what they are. I can't remember. They were good. I ate them on lunch. It was wonderful. Welcome. I don't know who was first in chat, so we need somebody to out the recipient or the pending recipient. Who was it? Who wasn't? We need to know. We need to know before we go to court.
Hello.
Let's see who it was. Was it Lindsay Lou? Shar Mom? Who was first? Oh, Paula Mac. Oh my goodness. If only they allowed that. Well, they don't. But Shar Mom, were you first? Who was first in chat this afternoon? Somebody has to know. Fess up if it was you. You know if it was you. Not Paula Mac. I don't want the internet today, of all days. Allie B says, I'll take it. Well, if I don't hear anything different here in the next couple seconds, Allie B, I'm going to gift it to you. It was Shar. Okay. Shar, congratulations. I Am Super T outed you, so if you have any problems with what you're about to get gifted, it's her fault. I'm sorry, Super T. Congratulations, you're first in chat. Because of that, we're going to punish you with internet ownership. Everything IP-related worldwide is your responsibility, at least until we go live again shortly. Chat not on screen. Fixed it. All right. I do think there's a very good chance that that I fall asleep this afternoon. We need the action to just go. We're going to have closing statements. And I don't know how long it's going to take. The judge is not here yet. But look, does the prosecutor look a little bit peeved with the fact that this case was blown out of the water by the defendant when he took the stand and testified? We'll see how this goes down. You know, she's just doing her job. The investigators, I guess, wondering if they're doing the right thing. Okay, so defense is there, prosecution's there, the court clerk's there. I saw Justin earlier. Now the judge comes in. Here we go. You will bring the jury.
You will bring the jury.
X was excellent on the stand. He sure was.
Oh, she's going to be in...
The judge is like, whoa, mics are hot. So my friend that's a business partner with our Airbnb also got a 3D printer. And so he printed this samurai sword handle, which inside of it has a expanding samurai sword. Right? And it makes that cool whistling noise when you put it in and out. But my son has broken the cap off, so I'm re-gluing it right now, hoping it will stay. So if my hand gets stuck to this permanently, it's because of the super glue. And yeah, Dang it. Okay, I spoke too soon. Needs more weight. I will tell you, the sword is a better decoration than it is a functional toy. But I think I have super glue on my hands now. It's okay, I'll just hold them together and it will be fine. Oh my goodness. Walmart in Virginia? What is happening?
Hello.
Waiting for the judge to turn on the mics.
In front of the Walmart.
Walmart. Do not super glue your hand to the samurai sword. I would always be ready for a fight if I did.
If you could just use your words.
Here comes the jury. Jury's a little chatty. I think they're ready to do their work this afternoon. Red pen, drive safe. Drive safe. Josh has got this.
Thank you. You may be seated. Ladies and gentlemen, we have heard all the testimony and the evidence has been presented, and we're now going to hear the closing arguments of counsel. Ms. Tranter, you may go first.
Let's see if her heart's in it. Let's see if her heart's in it.
Good afternoon, ladies and gentlemen.
Oh, she's angry. She's flipping those papers.
I told you at the beginning of this case, in opening statement, that this case is about protecting the integrity of our election system, the very foundation of our democracy. Initiative petitions, we have learned, are a vehicle to give voters a voice they can use to have issues that are important to them be placed upon election ballots. I told you that this process depends on honesty and trust. And now that you have heard all of the evidence, heard from the witnesses, seen the exhibits, we've shown to you how the defendant has violated that trust by signing petitions, possessing petitions with false signatures
You
on
said
documents
signing.
that he swore by penalty of law under possibility of election falsification prosecution that he witnessed the signatures on and that they were true and signed by the people whose name it was reported to be.
There's no requirement for identification.
He swore that he personally circulated these petitions and all the signatures were valid. Now, we also discussed how crimes in Ohio are made up of elements. So I'm going to spend a little bit of time with you talking about the charges and the elements that I believe that I've proven to you beyond a reasonable doubt. This is a 24-count indictment. As I told you at the beginning, don't get overwhelmed because there's 24 counts, because there's really only 2 charges that you have to work with the elements. Counts 1 through 12 are all election falsification charges. The language of that is on or about December 1st, 2023 through July 22nd of 2024. And that's such a date range because the incident can occur anytime between that time frame. The law in Ohio allows us to not necessarily have to do a specific date, but we can do a range of dates. And those dates encompass from the petitions that were just signed in December of 23 through when the investigation began in July of 2024 with the Lebanon Police Department. Obviously, we're in Warren County, Ohio. We're dealing with the Warren County Board of Elections here in Lebanon. And the meat of the charge, defendant Ezekiel Rouse did orally or in writing on oath lawfully administered or in a statement under penalty of election falsification, knowingly state a falsehood in a matter in relation to which an oath or statement under penalty of election falsification is authorized by law. That's a lot of words. Okay?
Words matter.
Don't get overwhelmed by the amount of words. Broken down, he submitted a writing, which is that statement of circulator that we've seen multiple times on all of these petitions. You're all going to have those to compare when you go back into the jury room, that he signed and swore those statements were correct. This is the statement of circulator. I, Ezekiel Rouse, declare under penalty of election falsification that I am the circulator of the foregoing petition. Paper containing the number of signatures is relevant to each exhibit of this case, 35 electors, that the signatures appended hereto were made and appended in my presence on the date set opposite each respective name, and the signatures are the persons of whose names they purport to be. Further stating that I witnessed the affixing of every signature to the foregoing petition paper, that all signers were to the best of my knowledge and belief qualified to sign, and that every signature is to the best of my knowledge and belief the signature of the person whose signature it purports to be. And a key phrase, whomever commits election falsification is guilty of a felony of the 5th degree. Counts 13 through 24 are all forgery charges. Same dates in Warren County, Mr. Rouse, with purpose to defraud or knowing that he was facilitating a fraud on another, did utter, possess, or with purpose to utter,
with purpose,
a writing that defendant knows to have been forged. Again, that's a lot of words. And what those words mean is that I don't have to prove to you that he is the one who signed those names of those 12 citizens that we're talking about. All that I, as the state of Ohio, have to show
is that he knows.
With purpose to defraud or knowing that he was facilitating a fraud, he uttered or possessed with purpose to utter. Gave to Boots, turned in these signatures. You don't have to prove that it was his pen on the paper signing Barry Riley's name, Ashley or Mrs. Ashby's name. We just have to prove that he possessed it with knowledge that those signatures had been forged. Now, counts 13, 14, and 15 have just one additional line for another element that has to be shown, and this is the elderly victim. As you recall, this is Melody Ashby, James Ashby, and Alan Hicks. Furthermore, on those counts, the victim of the offense is an elderly person or a disabled adult. Disabled adult is not going to be relevant here. It's going to be an elderly person, and the judge is going to tell you during your jury instructions that an elderly person under Ohio law is over 65. Now, each of these counts, each of these 12 victims are attached to two separate counts. One count of election falsification, one count of forgery. Mr. Hicks, Alan Hicks, he's going to be attached to counts 1 and 13. His date of birth is 7/18/53, making him 70 years old at the time. You're going to have the petition that is his name and his address and a signature that allegedly purports to be his, in addition to the voter registration card that we talked about for each of these individuals. Melody Ashby is going to be your victim on counts 2 and 14. Date of birth June 7, 1947, 76 years old at the time. in Ms. Ashby's petition and voter registration card comparison. James Ashby, counts 3 and 15, date of birth, March the 2nd, 1945, 78 years old at the time. And as you recall, Mr. Ashby is the one who has since passed since this investigation happened. But you'll recall Miss Melody Ashby's testimony that they were married for over 50 years. She had seen her husband's signature many, many times and testified that the signature on the card, the voter registration card, was her husband's. The signature on the petition was not her husband's. And if you recall, in this particular one, she even pointed out how on the box it says James Ashby Jr., and while he was a junior, he never used that in filling out paperwork or signing that. That was just something that wasn't in his normal routine to do. Barry Riley. Sheriff Riley is attached to counts 4 and count 16. And there's his purported signature on the petition versus his voter registration card. Counts 5 and 17 belong to Craig Schwartz. Same thing for Mr. Schwartz. Comparison of the voter registration card versus the petition. Joy Friday. Ms. Friday is attached to counts 6 and 18. And again, comparison of the petition versus her voter registration card. Obviously quite a difference there. Caitlin Dressler, counts 7 and 19.
The defendant's nodding.
Caitlin's voter registration card versus her purported signature on the petition. Adam Dressler, her husband, counts 8 and 20. And again, Mr. Dressler's voter registration card versus the signature that appears on the petition. Kim Flouting, counts 9 and 21. Picture of Kim's signature on a voter registration card versus the signature that's purporting to be his on the petition. Taylor Morgan, counts 10 and 22. Taylor's signature on the voter registration document versus the signature on the petition. Counts 11 and 23, Laura Morgan, and Laura's signature on her voter registration card versus the petition. And finally, Scott Rayberg, counts 12 and 24, and Mr. Rayberg's signature on his voter registration card versus the signature on the petition. And for reference, we have Stephen Drake, who you heard from, who testified that he did in fact sign that petition, knows Mr. Rouse and identified him, and that is his signature. Along with Joanna Weaver, who also testified that she knows Mr. Rouse. And while she doesn't have a specific memory of signing the petition, she did verify that the highlighted area is in fact her signature. You've heard testimony from a lot of witnesses in this particular case. You've heard from 11 citizens. Alan Hicks came in, swore under oath, and testified that the signature on the petition was not his. He does not know the defendant. He did not sign that. But the information that occurs on the petition is, in fact, his correct address was at the time that the petition was signed. Same thing for Melody Ashby. She told you she did not sign this petition. She told you that that was not her signature. But the address that appears on the petition was, in fact, hers at the time of the offense. Testified as to James, as we talked about. She testified that the signature on the petition was not her husband's. Signature looks nothing like her husband's. They had been married for over 50 years. She knows what his signature looks like. But again, the address on the petition was correct at the time it was signed. You heard from Sheriff Barry Riley. Same thing. He did not sign the petition. He does not, the information that was contained on the petition was his correct address at the time, but his signature was not his. Craig Schwartz told you the same thing. Not my signature.
His signature was not his.
That is my address. Joy Friday, not my signature, but that is my address. Caitlin Dressler, not my signature, but that is my address. Adam Dressler, not my signature, but that is my address. Kim Flouting, not my signature, but that is my address. Taylor Morgan, not my signature, but that is my address. Laura Morgan, not my signature, but yes, that's my address. And the same for Scott Rayberg. That is not my signature, but that is in fact my address. 11 people told you that they did not sign that petition. Aside from those 11 people, Detective Jenkinson said out of the 226 names on the petitions that he was provided by Brian Sleeth and the Board of Elections, that over 100, I think 126, were not valid, were not held to be valid by the Board of Elections. But given time constraints, and at some point you got to draw the line on an investigation and say we're complete. He didn't talk to everybody, but he talked to a heck of a lot of people. You heard from Mr. Williams this morning. Boots, as everybody knows him by, testified that the defendant worked for him. He was part of his team. And some unusual things may have happened with the defendant. It wasn't all that common to have somebody drive to their locations, but the defendant wanted to do that. He told you that he had multiple conversations with the defendant about the importance of validating signatures, making sure that the name is legible, making sure that the address is legible, making sure that the date, as you recall, one of the dates was January of 23. It should have been January of 24. That's something that could invalidate a signature. Said he had multiple conversations with him, and not only Mr. Rouse, but his team in general, about the validity of signatures, because they needed to get so many to get this issue on the ballot. He told you that he personally would train these individuals what they're supposed to do when they're going out to collect signatures. He told you, the basic spiel. Hi, are you registered to vote? You registered to vote in Ohio? What county? Are you interested in signing the petition? That's it. No IDs were checked. No driver's license were presented. In fact, they weren't allowed to ask for a state ID or a driver's license, which would have displayed an address on the plastic. They weren't allowed to do that. They would hand the petitions over, they would sign, fill out the address, and hand them back. Detective Jenkinson, you heard from briefly, and saw the most important part of his testimony is his interview, or his approaching the defendant in the parking lot. I don't even really call it an interview. It was more like a conversation, really. He goes up to the defendant, as you saw, says, "Hey, are you Mr. Rouse? Are you Exekia? Yeah, I just wanted to talk to you about this advanced micro-targeting and how you came to work with them." That's it. That is the only question the detective asked him, and it's not even really a question. Just sort of, "Hey, this is why I'm talking to you." At that point, the defendant then spills his guts and says, "Oh yeah, they accused me of forgery 2 to 3 times before. This has happened before." No questions about forgery, no talk about forgery, no talk of anything of a nefarious nature. Just like, "Oh hey, how'd you get to work with them?" He brings it up on his own. Clearly, this is something that's at the front of his mind, and the fact that he is being approached by a police officer, he's thinking about that, and he's saying this to get ahead of himself. ladies and gentlemen, I'm going to have another opportunity to stand up and talk to you after Mr. Gibbs gets up here, and I'm going to do so. But at this point, I'm going to leave you thinking about the elements, and I will ask you ultimately to find the defendant guilty. And at this point, I'm going to turn it over to Mr. Gibbs.
Thank you, Mr. Gibbs.
We'll give the rest of my presentation. Mr. Gibbs, you got to bring this one home, bud.
Ladies and gentlemen of the jury, as we discussed earlier, the defendant is presumed innocent until guilt is established beyond a reasonable doubt. The defendant must, by our Constitution, must be acquitted unless the state provides evidence which convinces each and every one of you jurors beyond a reasonable doubt that each and every essential element of each and every of these 24 charges has been proven. Amy got into some of the charges and laid out some information. You're certainly going to hear more of that from the judge.
First name
I won't belabor it, but it's certainly the position of the defense that the state has not provided and met that level, that burden. It has not been shown clearly by the evidence that my client knowingly stated a falsehood with regards to election falsification. Further, through this span of time between December 1st of 2023 and July 22nd of 2024, it would be the position of the defense that the state has not shown beyond a reasonable doubt that my client, with purpose to defraud or knowing he was facilitating a fraud, uttered, possessed, or with the purpose to utter a writing he knew was forged. Now, I understand and agree with the prosecutor's office in saying they don't have to prove that my client sat and specifically wrote down the names that showed up that weren't supposed to be there. But I will ask you, the alternative, really relies on, for him to knowingly be involved, is there some type of grand conspiracy where he has people under him, doing it? If you look to the signatures, they appear to be pretty markedly different. Although, of course, we didn't have a handwriting expert give an opinion, but it appears from block to block that seemingly someone different wrote them. I believe the state has very clearly proven, beyond any question of reasonable doubt, that these 12 people did not sign that petition. We don't contest that in the slightest. We're not trying to say, oh yes, they actually did it and they're lying. We're not trying to say anything along those lines. There's no dispute about that. The question, though, isn't whether the names are there, it's how they got there, and what was in the heart and the mind of the man sitting at the defense table. At the start of this case, I asked you one key question in opening remarks, and that was, I asked you to look for why. I asked you to look for why. And now the evidence is in, and why is still missing. There's no financial, zero, zip. That has been testified to by Boots, testified to by the defendant himself. I believe even in the officer's testimony, it is crystal clear that circulators do not get any financial benefit whatsoever based on the number of signatures they provide. Further, there's no promotion, there's no bonus, there's nothing that could seemingly be an intangible, non-financial benefit to inflating numbers of signatures. There just is no benefit there. There's no why. However, there very clearly is the risk of a felony conviction. So you have one side of the scale, so to speak, with the pretty heavy issue of a felony conviction, or in this case, numerous felony convictions. Typically, people act rationally. The other side of that, there just isn't a benefit that comes anywhere near balancing that weight. Now, excuse me. if those 12 signatures in the pile, and again, pretty clearly are not by the individuals who they claim to be, it would be the defense's position that that's really at the fault of AMT in their validation process. We've heard testimony that there's the initial check, and then there's this secondary check, which again, Mr. Boots gave some insight into about how he said the company was a little bit vague about it, but that they were, kind of played up, that they have, handwriting experts or something to that effect, that, they really are careful on their signatures and verifying them. So all of the petitions that were turned in went through both of those processes. They went through the initial manager checking them, went through this somewhat opaque secondary AMT validation system, and then were sent on to the Secretary of State's office. That clearly reflects a failure if they are checking the signatures and checking them against recorded voter registration information, as again, clearly it appears that these 12 are not accurate signatures. Now, the judge is going to instruct you on not just these charges and the elements, but he's going to instruct you on reasonable doubt. If you come to the point of saying, and again, I don't like to say this, but this is constitutionally the standard, even if you think, yeah, he probably did it, but not beyond a reasonable doubt, it's supposed to be not guilty. Now, ultimately, if you believe he signed the papers because he was relying on his training and the company, and he didn't purposefully do anything that he's been accused of in this, then we would certainly request that you come to a not guilty and that you acquit. Again, the prosecution has certainly proved these 12 names very clearly. They haven't shown you a witness claiming Mr. Rouse wrote any of them. They haven't shown you a single reason why he would. Therefore, we humbly request that you return a verdict that follows the logic of this evidence and a verdict of not guilty on all counts. Thank you.
Thank you. Ms. Tranter?
Bit of a low-budget delivery there, but he hit the important points just without the passion I was hoping he would present.
Proof of motive is not required. That's going to be in your instructions. So if you're looking for why, stop. Because you don't have to look for why. Why is not an element that I must show to you as the state of Ohio beyond a reasonable doubt. Whether or not you agree with that, it doesn't matter. Because as a juror, you have taken an oath to uphold the law as the judge gives it to you, and that's part of the law. And the judge is going to tell you in just a few minutes, proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose or knowledge. I don't have to prove to you why Mr. Rouse did this, okay? I have to prove to you beyond a reasonable doubt the elements that we just went over. Maybe it was cold outside in January and December and he didn't feel like standing out in the cold to get signatures. Maybe he had errands to run. Maybe he had stuff to do for Mr. Ernst. Maybe he just wanted to go back home and go to bed. It doesn't matter why he did it. I don't have to show that to you. The fact of the matter is that we have shown to you beyond a reasonable doubt that he did commit the crimes he is alleged to commit. Remember back in voir dire, we had extensive conversations about direct evidence versus circumstantial evidence. We had a lot of time discussing about how they're of equal weight. And the judge even told you in his opening instructions, and he's going to tell you again, a conviction based upon circumstantial evidence is no less effective than a conviction based on direct evidence. They are equal weight under the law. Remember that snowflake example that I gave. You don't have to be awake in the middle of the night and see the snow falling to know that it snowed. You can wake up in the next morning, see your brown lawn the night before, wake up in the next morning, and all of a sudden your lawn is white, covered in snow, and
Why
you
is your
know
lawn
that it
brown?
snowed overnight.
What if it was
As we
green?
discussed, one proves that fact just as easily as the other. Okay? So keep that in mind as you're going through. We also talked about how we insist that you use your common sense. This case has common sense written all over it. How logical is it for someone, a random person, to know your address? If you think about it, how many...
She went here?
In our everyday lives, how many addresses of some random person could we just rattle off and have
There's
it
one at
correct?
Pennsylvania Avenue, I know.
All of these people came in and said, my information on this petition is mine. This is the address where I lived at on January 4th or December 22nd, whenever those petitions were signed. Yes, that's my correct address. Brian Sleeth told you that is a very simple process. It's available on the website any day, either the Board of Elections or the Ohio Secretary of State website. Just go on there, plug it in, pull a list of voters, and you can have their current registration address and their name. Very simple for defendant or anyone else to go on and do it. It doesn't make sense that if I go up and sign Mr. Gibbs's name on a petition, that I would be able to give Mr. Gibbs's correct registered voting address on that petition. Common sense, it defies all common sense and logic.
But his boss has like 50 examples of his signature and
defendant
address right in front of him.
expects you to believe that someone came up and signed the name of Alan Hicks on that petition and put the address down as Alan Hicks's registered address. Not only Alan, but every other witness that we called, all 12 of them. James Ashby, Melody Ashby, Taylor Morgan, Laura Morgan, Alan Hicks, Mr. Schwartz, Miss Friday, Mr. Rayberg, Barry Riley, all of them. He expects you to believe that some random person came up, signed a petition, and got that address right for 12 people. It makes absolutely no sense. Another interesting point too, you heard the defendant testify, and I went through all the petitions with him, all 5 of them, okay? And coincidentally enough, the only petition that he says his signature is not his is State's Exhibit number 1. You know whose signature is alleged on State's Exhibit number 1?
The sheriff.
First box, Barry Riley. The most identifiable person that we've talked about in this courtroom for the past 2 days. Barry's identity is not a secret, okay? He is the sheriff of this county. It is very simple for anyone to come in here and say, I know Barry Riley. In fact, he did. He said he knows him. Is it a coincidence that the one page that he says, nope, not my signature, has Mr. Riley's signature on it? Alleged signature. Again, not a coincidence. We also talked about credibility a lot, judging a person's credibility. And another thing we talked about was if they have a motive to lie. Take that into consideration. who has a motive to lie in this case? What benefit would Mr. Riley or any of these other people who came in, what benefit would they have to say, come in and lie about signing a petition? What benefit would Boots have to come in and say, Mr. Rouse sat in front of me and signed all of these petitions in my presence?
Well, if he wants to keep his butt out of jail, if he did something wrong.
Every single one of these petitions, the number on the back page that he certified in front of Mr. Williams is going to match the total number of votes, okay? Every single one of them. So there's no issue at all with separating pages and whatnot. They all match up. They all go together. They're all in sync. Mr. Williams testified to you that he signed them, and Mr. Williams testified he takes his job very seriously. He went through each of these petitions with not only Mr. Rouse, but everybody who worked for him.
Yep, all 40 of them.
What
about
motive
an hour,
would he
10
have
minutes each.
to come in
Do the math.
and testify falsely?
40 an hour, 10 minutes each.
I, Executive Rouse, under penalty of election falsification, certify that I am the circulator of the foregoing petition containing 35 signatures. The signatures appended hereto were made and appended in my presence on the date set opposite each respective name, and the signatures are of the persons whose name they purport to be. I witnessed the affixing of every signature to the petition. All signers were, to the best of my knowledge and belief, qualified to sign. And every signature is, to the best of my knowledge, the signature of the person who purports it to be. Which, by the way, if we want to dissect that, I witnessed the affixing of every signature to the foregoing petition paper. If you believe his testimony, he didn't witness them. He told you that he had these petitions and he would just hand them to somebody and say, okay, go ahead and do your thing, and then he'd go over here and talk to the next person. So if we want to get technical about it, he didn't witness anybody signing it. Whoever commits election falsification is guilty of a felony of the 5th degree. That is the case here, ladies and gentlemen. Mr. Rouse has been proven guilty beyond a reasonable doubt of 24 counts, 12 counts of election falsification, 12 counts of forgery, and we ask that you return a verdict of guilty on all counts. Thank you.
We're going to do a poll here during jury instructions.
Members of the jury, you've heard the evidence and the arguments of counsel, and it is now my duty to instruct you on the law. The court and the jury have separate functions. You decide the disputed facts, and the court provides you with the instructions of law. It is your sworn duty to accept these instructions and apply the law as I give it to you. You are not permitted to change the law or to apply your own idea of what you think the law is or ought to be. Well, the case before you began with the filing of an indictment. The indictment informs the defendant that he has been charged with a crime. You may not consider the fact that it was filed for any purpose. A plea of not guilty is a denial of the charges and puts at issue all of the essential elements of the crimes charged in that indictment. The defendant is presumed innocent until guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offenses charged. Reasonable doubt is present when you, after having carefully considered and compared all the evidence, cannot say you are firmly convinced of the truth of the charges. It is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of the person's own affairs. So what is evidence? Evidence is all the testimony received from the witnesses and the exhibits admitted during the trial. You may consider both direct and circumstantial evidence. You must decide from all the direct and circumstantial evidence taken together whether the state has proven all of the elements beyond a reasonable doubt. Direct evidence is the testimony given by a witness who has seen or heard the facts about which the witness testifies. It includes any exhibits admitted into evidence during the trial and stipulations that you were instructed to accept as fact. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts that naturally and logically follow according to the common experience of people. Direct evidence and circumstantial evidence are of equal weight. Direct evidence and circumstantial evidence possess the same probative value. In some instances, certain facts can only be established by circumstantial evidence. A conviction based solely on circumstantial evidence is no less sound than a conviction based on direct evidence. To infer or to make an inference is to reach a reasonable conclusion of fact that you may, but are not required to make, from other facts that you find have been established by direct evidence. You may infer a fact or reach a conclusion only from other facts that have been proved by direct evidence. Whether an inference is made rests entirely with you. The evidence does not include any statement made by counsel during the trial unless such statement was an admission or agreement of certain facts. The opening statements and closing arguments are not evidence. They are designed to assist you in evaluating that evidence. The evidence does not include any statements that were stricken by the court or that you were instructed to disregard. You must not speculate why an objection was sustained to any question or what the answer to the question might have been, because these are questions of law and rest solely with the court. You are the judges of the facts and the credibility of the witnesses and the weight of the evidence. To weigh the evidence, you must consider the believability of the witnesses, and to do this, you will use the tests of truthfulness that you use in your daily lives. These tests include the appearance of each witness upon the stand, the witness's manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which the witness testified, the witness's accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Use these tests and assign to each witness's testimony such weight as you think proper. You are not required to believe the testimony of any witness simply because the witness was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to decide what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. The testimony of a law enforcement officer is to be weighed by the same rules that apply to other witnesses. You are to weigh the testimony of the defendant by the same rules that apply to other witnesses. A number of exhibits and the testimony related to them have been introduced. You may consider whether the exhibits are the same objects and in the same condition as when they were originally taken. You will determine what weight, if any, the exhibit should receive in light of all the evidence. A video recording and testimony relating to it has been introduced into evidence. You shall consider whether the video is a true record of what transpired at the time it was taken. If you find that it is, you will then determine what weight, if any, the video should receive in light of all the evidence. As to count one, the defendant is charged with election falsification. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024, and in Warren County, Ohio, the defendant did orally or in writing, on oath lawfully administered, or in a statement made under penalty of election falsification, knowingly stated a falsehood as to a material matter relating to an election in relation to which an oath or statement under penalty of election falsification is authorized.
Bree, that's awesome.
This count one relates to Alan Hicks. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. When knowledge of the existence of a particular fact is an element of an offense, such knowledge is established if a person subjectively believes that there is a high probability of its existence and fails to make inquiry or acts with a conscious purpose to avoid learning the fact. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that election falsification would occur. Material is defined as having real importance or great consequences. The state must prove beyond a reasonable doubt that the false statement was made orally or in writing, in a document or proceeding where the law authorizes or requires the statement to be made under penalty. This element can be met if the document itself is one that the law requires to be submitted under penalty of election falsification, which contains the language, "Whoever commits election falsification is guilty of a felony of the 5th degree." If you find the state proved beyond a reasonable doubt all the essential elements of election falsification, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of election falsification, then your verdict must be not guilty. As to count 2, the defendant is charged with election falsification. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024, and in Warren County, Ohio, the defendant did, orally or in writing, on oath lawfully administered, or in a statement made under penalty of election falsification, knowingly stated a falsehood as to a material matter relating to an election in relation to which an oath or statement under penalty of election falsification is authorized. This count relates to Melody Ashby. The court has previously defined knowingly, material matter, and oath or statement under penalty of election falsification, and these definitions shall also apply here. If you find the state proved beyond a reasonable doubt all the essential elements of election falsification, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of election falsification, then your verdict must be not guilty. As to count 3, the defendant is charged with election falsification. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024, and in Warren County, Ohio, the defendant did, orally or in writing, on oath lawfully administered, or in a statement made under penalty of election falsification, knowingly stated a falsehood as to a material matter relating to an election in relation to which an oath or statement under penalty of election falsification is authorized. This count relates to James Ashby. The court has previously defined knowingly, material matter, and oath or statement under penalty of election falsification, and these definitions shall also apply here. If you find the state proved beyond a reasonable doubt all the essential elements of election falsification, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of election falsification, then your verdict must be not guilty. As to count 4, the defendant is charged with election falsification. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024, and in Warren County, Ohio, the defendant did, orally or in writing, on oath lawfully administered, or in a statement made under penalty of election falsification, knowingly stated a falsehood as to a material matter relating to an election in relation to which an oath or statement under penalty of election falsification is authorized. This count relates to Barry Riley. The court has previously defined knowingly, material matter, and oath or statement under penalty of election falsification, and those definitions shall also apply here. If you find the state proved beyond a reasonable doubt all the essential elements of election falsification, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of election falsification, then your verdict must be not guilty. Count 5. The defendant is charged with election falsification. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024, and in Warren County, Ohio, the defendant did, orally or in writing, on oath lawfully administered, and or in a statement made under penalty of election falsification, knowingly stated a falsehood as to a material matter relating to an election in relation to which an oath or statement under penalty of election falsification is authorized. This count relates to Craig Swartz. The court has previously defined knowingly, material matter, and oath or statement under penalty of election falsification, and those definitions will also apply here. If you find the state proved beyond a reasonable doubt all of the essential elements of election falsification, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of election falsification, then your verdict must be not guilty. Defendant is charged on count 6 with election falsification. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024 in Warren County, Ohio, the defendant did, orally or in writing, on oath lawfully administered, or in a statement made under penalty of election falsification, knowingly stated a falsehood as to a material matter relating to an election in relation to which an oath or statement under penalty of election falsification is authorized. This count relates to Joy Friday. The court has previously defined knowingly, material matter, and oath or statement under penalty of election falsification, and those definitions shall apply here. If you find the state proved beyond a reasonable doubt all of the essential elements of election falsification, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of election falsification, then your verdict must be not guilty. Count 7. The defendant is charged with election falsification. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024, and in Warren County, Ohio, the defendant did, orally or in writing, on oath lawfully administered, or in a statement made under penalty of election falsification, knowingly stated a falsehood as to a material matter relating to an election in relation to which an oath or statement under penalty of election falsification is authorized. This count relates to Caitlin Dressler. The court has previously defined knowingly, material matter, and oath or statement under penalty of election falsification, and those definitions shall also apply here. If you find the state proved beyond a reasonable doubt all of the essential elements of election falsification, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of election falsification, then your verdict must be not guilty. Count 8. The defendant is charged with election falsification. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024, and in Warren County, Ohio, the defendant did, orally or in writing, on oath lawfully administered, or in a statement made under penalty of election falsification, knowingly stated a falsehood as to a material matter relating to an election in relation to which an oath or statement under penalty of election falsification is authorized. This count relates to Adam Dressler. The court has previously defined knowingly, material matter, and oath or statement under penalty of election falsification, and those definitions shall also apply here. If you find the state proved beyond a reasonable doubt all of the essential elements of election falsification, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of election falsification, then your verdict must be not guilty. Count 9. The defendant is charged with election falsification. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024, and in Warren County, Ohio, the defendant did, orally or in writing, on oath lawfully administered, or in a statement made under penalty of election falsification, knowingly stated a falsehood as to a material matter relating to an election in relation to which an oath or statement under penalty of election falsification is authorized. This count relates to Kim Flotting. The court has previously defined knowingly, material matter, and oath or statement under penalty of election falsification, and those definitions shall also apply here. If you find the state proved beyond a reasonable doubt all of the essential elements of election falsification, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of election falsification, then your verdict must be not guilty. Count 10. The defendant is charged with election falsification. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024 in Warren County, Ohio, the defendant did, orally or in writing, on oath lawfully administered, or in a statement made under penalty of election falsification, knowingly stated a falsehood as to a material matter relating to an election in relation to which an oath or statement under penalty of election falsification is authorized. This count relates to Taylor Morgan. The court has previously defined knowingly material matter and oath or statement under penalty of election falsification, and those definitions shall also apply here. If you find the state proved beyond a reasonable doubt all of the essential elements of election falsification, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of election falsification, then your verdict must be not guilty. Count 11. The defendant is charged with election falsification. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024, and in Warren County, Ohio, that the defendant did orally or in writing, on oath lawfully administered, or in a statement made under penalty of election falsification, knowingly stated a falsehood as to a material matter relating to an election in relation to which an oath or statement under penalty of election falsification is authorized. This count relates to Laura Morgan. The court has previously defined knowingly material matter and oath or statement under penalty of election falsification, and those definitions shall also apply here. If you find the state proved beyond a reasonable doubt all of the essential elements of election falsification, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of election falsification, then your verdict must be not guilty. Count 12. The defendant is charged with election falsification. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024, and in Warren County, Ohio, the defendant did orally or in writing, on oath lawfully administered, or in a statement made under penalty of election falsification, knowingly stated a falsehood as to a material matter relating to an election in relation to which an oath or statement under penalty of election falsification is authorized. This count relates to Scott Rayburn. The court has previously defined knowingly material matter and oath or statement under penalty of election falsification, and those definitions shall also apply here. If you find the state proved beyond a reasonable doubt all of the essential elements of election falsification, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of election falsification, then your verdict must be not guilty.
Well, the judge continues reading. We're going to end the poll.
The defendant is charged with forgery. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024, and in Warren County, Ohio, the defendant, with purpose to defraud, or knowing that he was facilitating a fraud, uttered or possessed with purpose to utter a writing which he knew was forged. This count relates to Alan Hicks. Purpose is an essential element of the offense of forgery. A person acts purposely when it is his specific intention to cause a certain result. It must be established in this case that at the time in question there was present in the mind of the defendant a specific intention to defraud. When the essence or gist of the offense is a prohibition against conduct of a certain nature, a person acts purposely regardless of what the person intended to accomplish thereby, if it was the person's specific intent to engage in conduct of that nature. The purpose with which a person does an act is determined from the manner in which it is done, that the means used, and all other facts and circumstances in evidence. Defraud means to knowingly obtain by deception some benefit for oneself or another, or to knowingly cause by deception some detriment to another. The court has previously defined knowingly, and you shall use that same definition here. Deception means knowingly deceiving another or causing another to be deceived by any false or misleading representation, by withholding information, by preventing another from acquiring information, or by any other conduct, act, or omission that creates, confirms, or perpetrates a false impression in another. Perpetuates, I think the word I'm looking for, a false impression in another, including a false impression as to the law, value, state of mind, or other objective or subjective fact. Facilitating means helping, promoting, assisting, or aiding.
Just use your
Forge
words.
means to fabricate or create in whole or in part, and by any means, any false writing, or to make, execute, alter, complete, reproduce, or otherwise claim to authenticate any writing when the writing in fact is not authenticated by that conduct. Writing means any computer software, document, letter, memorandum, note, paper, plate, data, film, or other thing having in or upon it any written, typewritten, or printed matter, and any token, stamp, seal, credit card, badge, trademark, label, or other symbol of value, right, privilege, license, or identification. Utter means to issue, publish, transfer, use, put or send into circulation, deliver, or display. If you find the state proved beyond a reasonable doubt all of the essential elements of forgery, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of forgery, then your verdict must be guilty. This count, as well as counts 14 and 15, have a required additional finding.
Your Honor, apologies, I believe the last statement was,
I'm sorry?
I believe the last statement was not guilty. I apologize.
Did I not say that?
Yes, Your Honor, you said guilty twice.
Oh, thank you. I've been reading for quite a long time here.
I understand.
So bear with me, and I apologize because that's not my intent. I'm literally trying to read this word for word. Thank you,
No,
Mr. Gibbs.
Could you start over at the beginning, Your Honor?
All right, let me back up. This is count 13. If you find the state proved beyond a reasonable doubt all of the essential elements of forgery, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of forgery, then your verdict must be not guilty. If your verdict is guilty on this offense, on this count, as well as counts 14 and 15, you will separately decide whether the state proved beyond a reasonable doubt that the victim of the offense is an elderly person. An elderly person means a person who is 65 years of age or older. If you find the defendant not guilty, you do not need to make that additional finding. As to count 14, the defendant is charged with forgery. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024 in Warren County, Ohio, the defendant with purpose to defraud or knowing that he was facilitating a fraud uttered or possessed with purpose to utter a writing which he knew was forged. This count relates to Melody Ashby. The court has previously defined purposely defraud, fraud, knowingly, deception, facilitating, forged, writing, and utter. Those definitions shall also apply here. If you find the state proved beyond a reasonable doubt all of the essential elements of forgery, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of forgery, then your verdict must be not guilty. Again, this count has with it the additional finding. If you find the defendant guilty, you will separately decide whether the state proved beyond a reasonable doubt that the victim of the offense is an elderly person. If you find him not guilty, you do not need to make that additional finding. Count 15, the defendant is charged with forgery. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024 in Warren County, Ohio, the defendant with purpose to defraud or knowing that he was facilitating a fraud uttered or possessed with the purpose to utter a writing which he knew was forged. This count relates to James Ashby. The court has previously defined purposely defraud, fraud, knowingly, deception, facilitating, forged, writing, and utter, and those definitions shall also apply here. If you find the state proved beyond a reasonable doubt all of the essential elements of forgery, your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of forgery, then your verdict must be not guilty. This count also has the additional finding requirement. If your verdict is guilty, you will separately decide whether the state proved beyond a reasonable doubt that the victim of the offense is an elderly person. You do not need to make that finding if you find the defendant not guilty. Count 16. The defendant is charged with forgery. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024 in Warren County, Ohio, the defendant with purpose to defraud or knowing that he was facilitating a fraud uttered or possessed with purpose to utter a writing which he knew was forged. This count relates to Barry Riley. The court has previously defined purposely defraud, fraud, knowingly deception, facilitating, forged, writing, and utter, and those definitions shall also apply here. If you find the state proved beyond a reasonable doubt all the essential elements of forgery, your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of forgery, your verdict must be not guilty. Count 17. Defendant is charged with forgery. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024 in Warren County, Ohio, the defendant with purpose to defraud or knowing that he was facilitating a fraud uttered or possessed with purpose to utter a writing which he knew was forged. This count relates to Greg Swartz. Court's already defined for you purposely defraud, fraud, knowingly deception, facilitating, forged, writing, and utter, and those definitions apply to this count as well. If you find the state proved beyond a reasonable doubt all of the essential elements of forgery, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of forgery, then your verdict must be not guilty. Count 18. Defendant is charged with forgery. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024 and in Warren County, Ohio, the defendant with purpose to defraud or knowing that he was facilitating a fraud uttered or possessed with the purpose to utter a writing which he knew was forged. This count relates to Joy Friday. Court has previously defined purposely defraud, fraud, knowingly, deception, facilitating, forged, writing, and utter. Those definitions shall apply here. If you find the state proved beyond a reasonable doubt all of the essential elements of forgery, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of forgery, then your verdict must be not guilty. Count 19. The defendant is charged with forgery. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024 in Warren County, Ohio, the defendant with purpose to defraud or knowing that he was facilitating a fraud uttered or possessed with the purpose to utter a writing which he knew was forged. This count relates to Caitlin Dressler. The court has previously defined purposely defraud, fraud, knowingly deception, facilitating, forged, writing, and utter, and those definitions shall also apply here. If you find the state proved beyond a reasonable doubt all of the essential elements of forgery, your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of forgery, then your verdict must be not guilty. Count 20. The defendant is charged with forgery. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024 in Warren County, Ohio, the defendant with purpose to defraud or knowing that he was facilitating a fraud uttered or possessed with purpose to utter a writing which he knew was forged. This count relates to Adam Dressler. The court has previously defined purposely defraud, fraud, knowingly, deception, facilitating, forged, writing, and utter, and those definitions shall apply here. If you find the state proved beyond a reasonable doubt all of the essential elements of forgery, your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of forgery, then your verdict must be not guilty. Count 21. The defendant is charged with forgery. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024 in Warren County, Ohio, the defendant with purpose to defraud or knowing that he was facilitating a fraud uttered or possessed with purpose to utter a writing which he knew was forged. This count relates to Kim Flotting. Court has previously defined purposely defraud, fraud, knowingly, deception, facilitating, forged, writing, and utter. Those definitions shall also apply here. If you find the state proved beyond a reasonable doubt all of the essential elements of forgery, your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of forgery, your verdict must be not guilty. Count 22. The defendant is charged with forgery. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024 in Warren County, Ohio, the defendant with purpose to defraud or knowing that he was facilitating a fraud uttered or possessed with purpose to utter a writing which he knew was forged. This count relates to Taylor Morgan. The court has previously defined purposely defraud, fraud, knowingly deception, facilitating, forged, writing, and utter, and those definitions shall also apply here. If you find the state proved beyond a reasonable doubt all of the essential elements of forgery, your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of forgery, your verdict must be not guilty. Count 23. The
Almost
defendant
done.
is charged with forgery. Before you can find the defendant guilty, you must find beyond a reasonable doubt on or about December 1st, 2023 through July 22nd, 2024 in Warren County, Ohio, the defendant with purpose to defraud or knowing that he was facilitating a fraud uttered or possessed with purpose to utter a writing which he knew was forged. This count relates to Laura Morgan. The court has previously defined purposely defraud, fraud, knowingly, deception, facilitating, forged, writing, and utter, and those definitions shall also apply here. If you find the state proved beyond a reasonable doubt all of the essential elements of forgery, your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of forgery, your verdict must be not guilty. Count 24. The defendant is charged with forgery. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 1st, 2023 through July 22nd, 2024, and in Warren County, Ohio, the defendant with purpose to defraud or knowing that he was facilitating a fraud uttered or possessed with the purpose to utter a writing in which he knew was forged. This count relates to Scott Rayburn. The court has previously defined purposely defraud, fraud, knowingly deception, facilitating, forged, writing, and utter, and those definitions shall also apply here. If you find the state proved beyond a reasonable doubt all of the essential elements of forgery, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of forgery, then your verdict must be not guilty. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose or knowledge. Now you will have in your possession the verdict forms that apply to this indictment. There is a verdict form for each count of the indictment. So I have in my hand 27 pages, okay? There's 24 counts. There's a page for each count, okay? So, if you are all able to agree that the state proved beyond a reasonable doubt all of the essential elements as to count 1, you circle the word guilty and you must sign on your corresponding juror line in ink. If you find the state failed to prove beyond a reasonable doubt one of the essential elements of this charge for verdict count 1, you circle the word not guilty and you sign in ink. And then down here, once you've completed this one, it'll just tell you here, proceed to count 2. And you will proceed through each page like this until you get to count 13. Okay. Now, as was said in count 13, it's the same format. If you all agree that the state proved, what I've done is I've gone from the falsification now to the forgery charges. There's 12 of each, right? Count 13. Let me pull that one up. If you're all able to agree that the state proved beyond a reasonable doubt all of the essential elements of the charge of forgery as to this victim, you circle the word guilty and you sign on the corresponding juror line in ink. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of forgery, you circle the word not guilty and sign the form. Now remember, there's 3 counts. It's 13, 14, and 15 that also have an additional finding that's required. Okay, and again, this one relates to Alan Hicks. If you find him guilty of this count, you move and you do the additional finding. We, the jury, find that the state did or did not prove beyond a reasonable doubt that the victim was an elderly person. And you circle whatever your finding is, you circle the word and you sign this form in ink, and you move on to the next one. If you find him not guilty, the state failed to prove beyond a reasonable doubt any one of the essential elements, you circle the word not guilty and you skip the additional finding. You don't need to make that, okay? And you're going to do that for each of the 24 counts.
All right. Really, Julia, congratulations on beating the judge. Did he say give me a break?
The court has now instructed you on the law necessary for your deliberations. I will now instruct you on how to conduct your deliberations. When you go in the jury room, your first function will be to select one of your number to serve as a foreperson. The person you select to preside over your deliberations does not have greater power, nor does that person's vote have any more importance than the others. He or she serves the purpose of helping to conduct your deliberations in an orderly manner and to give each of you the opportunity to express your opinion. One additional duty of the foreperson is to see that the verdict forms are returned to the courtroom after you've reached your verdicts. Now, your initial conduct upon entering deliberations is a matter of importance. It is not wise to immediately express a determination or to insist on a certain verdict, because if your pride is aroused, you may hesitate to change your position, even if you later decide you are wrong. Consult with one another. Consider each other's views and deliberate with the objective of reaching an agreement, if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced it is wrong. However, you should not surrender honest convictions in order to be congenial or to reach a verdict solely because of the opinions of other jurors. It may be difficult to remember all of the evidence or the law. If you disagree as to the evidence, you should try to resolve the issue based on the collective memories of the jury. If you disagree about the law, refer to the written jury instructions which you'll have with you in the jury room. If you're still unable to resolve the issue, the court may, under certain limited circumstances, furnish such information. If you have a question, it should be reduced to writing so there's no misunderstanding as to what you request. Deliver the question to Justin, who will submit it to the court. Do not include the status of your deliberations in any question you might submit. You are not permitted to discuss or consider the subject of punishment. Your duty is confined to the determination of the guilt or innocence of the defendant. In the event you find the defendant guilty, the duty to determine the punishment is placed by law on the court. Furthermore, in reaching your verdicts in this case, you must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all of the disputed questions of fact, to apply the instructions according to your findings, and to render your verdicts accordingly. In fulfilling your duty, your efforts must be to arrive at just verdicts. Consider all the evidence and make your findings with intelligence and impartiality, without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will feel that the case was fairly and impartially tried. If during the course of the trial the court or any of my staff has said or done anything that you consider an indication of the court's view on the facts, you are instructed to disregard it. The judge must be, and I sincerely desire to be, impartial in presiding over this and every other trial. Since you'll have a copy of these instructions with you in the jury room, it's very important to bear in mind that no one part of these instructions is any more important than the other parts. The court cannot embody all law in a single part of these instructions. Only when they are considered as a whole do you have complete instructions of law applicable to this case. Now, there will be no cell phones or other electronic devices permitted in the jury room during deliberations. They will be collected by Justin, and they will be secured in my chamber area. Jurors selected as alternates are not permitted to participate in the jury's deliberations unless one or more of the regular jurors is unable to complete his or her service due to illness or other misfortune. Therefore, I will ask all 12 members of the jury, are you able to proceed to deliberations in this case? Ms. Keller, while the 12 members of the jury have indicated they are able to proceed to deliberations at this time, Justin will get your contact information and he will contact you if we need you. At this time, you are still bound by all of my previous instructions. Do not discuss the case with anyone or permit anyone to discuss it with you. Do not disclose to anyone how you would have voted. If we need you to return, Justin will get in contact with you. If not, Justin will contact you after the verdict is publicly announced, and at that time you will be released from these instructions. Okay? Okay, hang on just a few more minutes and we'll show you how. Okay. Now, the court will place in your possession the exhibits and the verdict forms. The foreperson will retain possession of those records, including the verdict forms, and return them to the courtroom for the public announcement of your verdict. The foreperson will see that your discussions are orderly and that each juror has an opportunity to discuss the case and cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. Until your verdicts are announced in open court, you are not to disclose to anyone else the status of your deliberations or the nature of your verdicts. After your verdicts are returned, you may discuss the case with anyone, but you're not required to do so. Whether you discuss this case with the attorneys or anyone else after you are discharged is a matter of your own free choice. Now, after you retire, select a foreperson. Whenever all 12 of you agree on a verdict, you'll sign the verdict forms as I've indicated in ink. Advise Justin by the buzzer in the courtroom, and at that time we will return you to the courtroom for the public announcement of your verdict. All right. Ms. Tranter, is there anything else?
No, sir, thank you.
Mr. Gibbs?
No, Your
All
Honor.
right, this time, ladies and gentlemen, I'm going to send you to the jury room to begin your deliberations.
All right, so when the door shuts, we're going to start our timer. Justin says, get up, you've got work to do now. You've been sitting around this whole time. Just kidding. Yes, it's true. The judge reading the instructions took longer than both the closing of both sides. It was a long one. It was lengthy.
What? It's just, if it was a different county.
Judge is still complaining about
Let me ask you guys a question.
reading these things.
Yeah. Just hypothetically, when you have that many repeating counts,
Just read
would
one.
you guys, I'm just trying to think, why would we try to shortcut that and just maybe say it a couple times and just say, this instruction's applied, you know what I'm saying?
That was going in the back of my mind, but
After I'm reading it.
yeah.
You know, and Marcus does a great job of not having to read all of the thing over and over again. We'd be here all
Right.
day. But it just seems to me that they get tired of hearing the same thing over and over again, too. That if we have that many counts, say, okay, this is the law that applies. But you don't want to shortchange either side because, okay, well, the judge didn't read this one, so this one's not as important.
Mm-hmm.
And sometimes you don't know what jurors are thinking. Does that make sense to everybody?
It absolutely makes sense, and I don't know what the right answer is because, I mean, I have had experiences where they have been combined, saying this count applies to blah, 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 blah.
Blah, 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 blah.
Where the
Those are
jurors
legal
have messed it
terms.
up.
Yeah.
I mean, I had one next door where we kind of condensed it and we all thought it was fine.
Yeah.
But they very clearly didn't understand the
Yeah.
instructions based upon their verdict.
But
And
this-
when we talked to them after and they said, oh, and it sort of dawned on them.
Yeah.
So,
But I think there's a way that you could explain it, you know, going through, like, now there's 12 counts, because this one's 12 and 12.
Right.
It's really two charges.
Could have been one and
right.
two.
I think this one would have been a good
Yeah.
one to
I missed an opportunity there.
consolidate. But
Anyway, next time that I have that many counts of the same thing, rather than just reading the same thing over and over again, it's just ridiculous. Or
Yeah.
just even condense it further and say, okay, count 2 is the same as count 1, but applies to this person.
right.
That would have made
Right.
more sense.
Yeah.
Anyway, all right, guys, you gonna stick around?
Yeah.
All right, and don't leave unless you let Mr. Gibbs know, okay? Just because if they come back, I'd like to get them moving. All right, thanks, everybody.
What's your plan here?
Well, I'm going to go get some food. Miss R.A. is back from taking one of our children to the doctor. That's exciting. Happy birthday, Mrs. R.A. Good news, everything's fine. Let's see. They were not listening. We've got a poll. Going. Let me close this poll out. This poll relates to just the time the jury's been deliberating. How long would the jury deliberate? 1 to 2 hours was 49% of you. Less than an hour, 38%. Less than 30 minutes, 6%. That means they have to sign signatures very fast. But if there's one thing that the jury is ready to do on this verdict, it's sign fast. They've been looking at signatures this whole court long. And they weren't listening 7%. Those are the people who think it's going to take longer than that. And I've never gotten a verdict time right. We're always wrong on that. I hit they were not listening. All right, as the timer counts up a little bit, we'll go to the 10-minute mark and readjust it because it has to wiggle around a little bit. Interesting. We're not going to get a lot of lead time on this one. So, Justin's rearranging the furniture in the courtroom. Prosecutor is going to put everything out in her car because she's done with this case. Just bagging it all up. I guess she's probably got an office not far from here. Justin's wondering why there's still those black gloves or whatever on the bar behind the prosecutor. Nobody knows whose they were. Somebody left them, probably a juror or a potential juror. Defendant's making a phone call right there in court because, hey, why not? What's the judge going to do about it? Throw you in jail? Maybe. So, good times all around. All right. Let's see. Both are great judges. Yes, and you got to meet them, so which is wonderful. I think we're going to be here for 3 to 4 hours. I really hope not. Here's what I'm going to do. Let me tell you what I'm going to do. If it goes that long, I'm going to record it. We're going to play it back tomorrow. I'm going out to eat with my wife. It's her birthday. I'm not going to mess this up for a verdict. I'm sorry. We'll play the verdict music tomorrow if it goes that long. Missed the cricket sweater earlier. Red Lobster, not Red Lobster. We're probably doing Mexican, which is always fun because you tell them it's her birthday and they'll come and sing a song that I don't know. It's not Happy Birthday. I guess it might be, but it's different. But I'm super excited. There's nothing I like better than like a good house fresh pico de is it gallo? Pico, yes, that one. Greener's that one. I called it gallo, and apparently it's not that. So, but anyway, so we're going to do that. She's working with the kids for school that we're a little bit behind today, so she's going to a little bit before that happens. Oh, look, guess who's coming back in? What's the defense? What do you think the odds are? Do you think defense is pretty confident on this one? I think they've got at least one juror firmly on their side, which, as long as that juror holds that position, would mean at bare minimum hung jury. But the jury did a good job. I was expecting more one-sided questions, especially from the defendant when he took the stand, and the jury took some pretty good questions. Oh man, he's upset at the prosecutor and how she closed. He's talking smack. I can tell. He's not happy. We did sing to Mrs. R.A. this morning. It's her birthday. For just a couple months, we're the same age, and then I get older than her in March. I'm a green chili enchilada connoisseur, says Blair. Those are good. A chicken. I prefer chicken when I do chili enchiladas. Or when I do enchiladas, I prefer chicken. I use Lori Vallo's recipe. Only I use fresh ingredients instead of a can. Let's see. Is it the one where they make the guac right in front of you? I don't know where that one is, but it sounds delicious. I'm okay with anything from Chipotle to like the food truck down the road, which makes amazing tacos. Oh my goodness. Green chili chicken enchilada sounds a bit wrong. Yes. Green chicken enchilada. You have to put the chili in between the green and the chicken. Otherwise, it's green chicken enchiladas. And that's not good. Yes, using Lori's memorable recipe. Oh, we've got a call. I'm not sure who this is, but it could be a prank call. Hello?
Hi, good afternoon, Dwayne.
Yeah.
Hi, sir. My name is Carl. I work with the fulfillment department here at Endless Getaways. I'm calling you in regards to the large number of travel credits you have on file with us. How are you today, sir?
I'm pretty good. What kind of credits are they?
Well, you have a 4-day, 3-night stay in Las Vegas, Nevada, either on or off the strip, your choice. You have a 4-day, 3-night stay in Orlando, Florida, just minutes from all the major theme parks and attractions. They've also included an 8-day, 7-night cruise. It's all inclusive. You choose from either the Norwegian, Carnival, or Royal Caribbean cruise line. All the food, entertainment, and the activities are included, good for 2 travelers.
Is it
The cruise
unlimited
all,
food? Like, is it buffet?
yes. Well, it's all inclusive, which just means all the food, the entertainment, and all the activities are included.
Like, if I
So
just ate
what?
steak all day, I could do that because I'm not really big about the trip, but I like the food.
Yeah. Well, in my mind, I'm thinking breakfast, lunch, dinner, breakfast, lunch, dinner, breakfast, lunch, dinner.
But I'm more like a breakfast,
Maybe
breakfast, lunch, lunch, dinner, dinner, dinner guy.
I hear you. And the last trip is a 5-day, 4-night flyaway stay. You get 25 different destination choices all throughout the
Is there
U.S.
in-flight meal on that one?
It's not specified, but this trip also comes with the 2 round trip airline tickets as well.
Okay.
So these are the 4 in your packages. So it says all you would be responsible for is a one-time booking and processing fee.
Do you have the menu for the cruise? Do you know what?
No, sir. Thank you for your time. You have a wonderful day.
Hey, how do I sign up?
How do you sign up? Are you really?
I love buffets, and if they've got one, I mean, cruise or no cruise, count me in. Carl, don't leave me here. Carl, you'll call back. You always do. All right. They gone. I never know what I was thinking about. Food. That's what happened. I was talking about going out to a restaurant. I could not think of anything else to say to him other than food. So he's like, you know what? You have a good day. It was the menu. The menu was too much. I should have gone with a more general question about food.
Happy birthday.
But Carl left for second lunch. He knew it was a scam and he couldn't sell it. Yeah. I miss the old school way of hearing the phone and hang up. Yes, endless vacations and forever getaways or something. Those are like the names they're using right now. They change their scripts every once in a while. Endless vacations is the one I hear a lot from them. Don't screw this up and get Mrs. R a vacation with meals included. Hello? With meals included for sure. Let's see. Legally Blonde says, Greeners, if you gift memberships, I'll send the modeling pics in the channel appropriate ones. Maybe to Facebook, right? Let's see. Get a chili relleno super burrito with asada for dinner. Ooh, that sounds like heartburn in a to-go bag. What? I mean, it sounds delicious as well. Don't get me wrong. But let me pin this for Josh. He's put it up a couple times and I've missed it. L is pronounced as a Y, as in yes. So it would be. So chile, it's not chile, but chile relleno super burrito. Are 2 R's together pronounced differently too? Is it like a G or something that I don't know about? Relleno. Why don't they just spell it this way? Relleno. What is in it? Can somebody now? Speaking of menus, what is in a chile relleno? Roll your R's, roll like that. I'm not very good at that. My mom's modeling pics from the 80s, not me. I'm built like my dad. Does your mom know we're sharing her modeling pics on the channel, Legally Blonde? And if we do, will it get you written out of the will? Just saying. It's stuffed peppers. I like stuffed peppers. Mrs. R.A. does not. She's not a big fan of cooked peppers like that. I mean, I think she can do like fresh peppers and salsa. That's pretty good, but something that looks like it's a mod chat. Another great use for mod chat. Pictures of food. This is good stuff, Josh. Thank you. Appreciate this. Apparently, I don't even have mod chat open today. What's been going on over there? Let me check. What in the world? Josh, I'm not sure what we're... Oh, there it is. I was looking at the wrong picture. It was like a screenshot from court. I'm like, I don't see it. And there's chili there? Or is it just the chili pepper? Not sure if this is... Not sure if that's what I have in mind tonight. I'm looking for something a little more substantial. It's a pepper. Ask for samples of everything. Does anyone in chat know the University of Florida in Gainesville? Any University of Florida alumni here, or maybe family members of someone who is currently attending or previously did? It's a pepper with cheese in it. I like the Mexican rice. I'm not... I love that defense is still here and thinking they're about to get a verdict. Let's see. Oh my goodness, we have pictures. Grainers, did you gift something? Did I miss? Legal Blonde. I didn't see the gifted memberships. Greener says, I most certainly did not gift. I have modeling pictures from Legally Blonde's mom, apparently. Is she still with us, Legally Blonde? Is she still with us? Or do I need her permission? Or are you like the estate that owns them? Do not show them, says Red Pen. Do not show them. We'll need a signed waiver. I can, let's see, as far as different pictures, 6, 7, 8, 9, 10, there's at least 11 pictures here. Okay. Do not show Liam's grandmother. Mr. X can give you a signed waiver. Yes. Thank you, Lee. That was perfect timing. Esbar, I work for UF. There you go. So, yes, we have somebody who knows. Yes, she is, and I have it. You have, like, power of attorney. Mexican food is different in every state. It is. And K-Knight, let me tell you, North Carolina is not the place to go if you like a wide variety, authentic Mexican food. It's just not here. Culturally, it's just not represented very well in our restaurants, or more specifically, in our grocery stores. There are a couple stores that have a pretty good selection, but we really lack when it comes to some of the fresh peppers. Honestly, fresh peppers is we don't have them. You can't find them. You're looking for an Anaheim or a chili, or I mean, you can get your habaneros and you can get your jalapenos. Those are and bell. Those are the three you can count on at any store. But if you want, a serrano, or something, no. Maybe a ghost. You probably get a ghost pepper before you find a serrano at the store. So, Texas has the best Mexican food. Mexico, I hear, is also high on the list. I sent your pronunciation to Chile Relleno to Mod Chat. Did you get it? I mixed it up. I saw the picture. Went to the line at Del Taco, blasting Taco Grande, but Weird Al Yankovic and the person serving us lost and laughing. Del Taco, they do a good job on their sauce, like their little packets of sauce. But it is, I would not call it Mexican fare. It's sort of like, it's Amex at best. Great, now I want Mexican. Not a sponsor. We're probably going to go to there's something that's like Mi Casa or Su Casa. I think it means my house, your house, something like that. I don't know. My Spanish is not up to par. We're probably going to go to one of those restaurants. And what is your favorite food? Generally, the one that's hot in front of me is what I like to eat. I'm a big fan of fresh food. Come to Arizona for good Mexican food. I tell you, I used to work in a story time. Let's gather round, folks. Gather round. I'll see if we can bring on. No, let's turn that off. I used to work in a metal shop. By metal shop, we're talking about not really fabrication, but more of a sheet metal shop where we bring in coils of like, I don't know, 29 gauge, which is pretty thin. It's like residential type metal roofing, all the way up to, I guess we had some 18 gauge that we'd use for like B decking, for structural decking. And we also made like purlins and things like the frame parts for the walls and the roofs. We make all this stuff. I used to work there. I forgot what I was. I had a buddy there. He was my boss first, then I became his boss. And then I got promoted and I went into sales. And I think he's still there. But his name was Isidoro Delgado. He had a name for me, but I can't repeat it on the air. And I think it means skinny, but I'm not sure. It wouldn't apply anymore. Anyway, so we worked together on a press break and got to know each other pretty well. Just a great guy. He's really funny. And he would bring food for lunch. Like I would bring like a peanut butter sandwich, okay, to eat at lunch. And he would bring like a 7-course meal. Okay. And it's in all these little, something like this. I think, I'm not sure. He had other words in front of it. Something about pinchers or something. I don't remember. He called me a lot of different things. They had fun names, but we did get along. I knew it was, it was derogatory, but we had a good time. Anyway, he'd bring his lunch cooler, and it had all these little dishes, and it had, you open them up, and like that, some of the sauces in there would just be like, that's gonna tear me up, and I want it. It was so good. Anyway, fantastic food. I really, really grew my love for Mexican food by working there at that metal shop, and that's where I also learned my recipe for fresh garden salsa, with your little garden salsa competition where people started bringing in, like a bunch of different people would bring in their recipes. Yes, something like this. There was, I can think of a couple words. I only know the bad words in Spanish, so I can't repeat them on the air. Sorry. Anyway, where were we? We were here. Looks like the defendant is going to take a break. Going to go for a little bit. We've got some time. They'll call us if the case gets decided right away. But if anyone's curious what the verdict will be, but the signs were there. Do you see the whole pig from the pig roast I sent you in mod chat? Yes, I saw that. The before and after, Josh. It was amazing. Good old pig roast. K Knight asking if anyone wants to open a learning center. K Knight, you're going to get us in trouble. Pickles, not politics. Pickles, not politics. Are you looking for grants? Because I hear there's money available. I was distracted answering the last question. Someone asked about Uvalde and why we're not going there. We are not following that trial. That was a choice we made to. I know it's going on. It will be a very emotionally heavy trial, and I didn't want to start out the year like that. I mean, every trial has a bit of emotional heaviness to it, right? As the facts hit close to home, or the victims are just it's heartbreaking situations. But except for this trial, this trial's a little bit different. Ooh, they're calling back. Hello.
Hello. Hello.
Hello.
This is Alice. How are you doing today?
Hello. Who is this?
We have been trying to reach you concerning your car extended warranty.
Yes, I've been waiting for this call.
In the mail about your car extended warranty since we have not got a response. We are giving you a courtesy call before we close out your file.
Alice, I need to talk to somebody about this. Is there somebody other than you that maybe could answer my questions? Alice? Are you there? I finally get the meme call and you hang up on me? We haven't had the car's extended warranty call ever. Alice. Oh, she's gone. She's gone. Carl set this up to prank you back. Yeah, I'm sure. It probably did. Probably did. Let's see. We did have a serious discussion in Mod Chat about the Valde case and ultimately decided not to cover this first trial live. We agree. It was my decision. I bounced it past the mods. They agreed with my take on it, which is always wonderful. I like hearing people tell me I'm right. But it was, it's not, I don't think it's the right trial for us to watch. Plus, the truth is, even though we're doing a little bit of court hopping in some of these court light cases, we have a smorgasbord of true crime cases coming up that we can choose from. And eventually, very soon this year, we're going to be like, there's too much to watch. There's too much to follow. We want to watch all of them at the same time. We're going to be there. I love court light. It is fun. I think it's important that we have some court light so we can get through the court heavies. There's Corey Riching hearing today. Yes, the judge, I believe Kathy Russin from Law and Crime tweeted out that the judge is going to allow them to air those on delay. They weren't live streamed, but aired on delay. And this is something the judge has done in that case many times. It's super frustrating. But for some reason, he thinks that a delay in the recording will fix something. I don't know what. Will fix a problem that exists. I cannot for the life of me figure out what the delay would actually fix. I nearly got in trouble when I was there at the Corey Richards trial at the first hearing. When we live streamed that, I was in the courtroom and we live streamed it from the press room. I did it with a delay because they said with delay, and so I didn't do it live. I put a delay on it, but they didn't specify the length of delay. And apparently the judge was hoping for a longer delay than the one I gave, which was probably, mine was about a 35-second delay on it. So, let's see. The Maribel, thank you very much. This is my wife's birthday, and we're super excited to go celebrate. It's smorgasbord. Did I say smorgasbord? I added a SH. I added 2 H's in there. Every S has an H after it when I pronounce it. Let's see. I think the Richmond judge has had his head in the sand a bit regarding the internet. He's not up to the times a little bit, which is sad because the first civil case in Utah that was ever aired on TV was aired out of that courthouse. That was the Gwyneth Paltrow case, right? Up there in Park City. But now they've got this big criminal case and they're doing it backwards. So every S has an H after it when RA says it. That time RA told me to sit on my couch. Oops. Greeners. You're in trouble. And now I need to I forgot to fix the numbers. I will do that now. Give me a second. Wait for it. And let's get a little more on the left side, a little more space. Space on 2. All right, there's our timer. Few of you that chose for 30 minutes or less. Looks like you're not going to make it. With nobody back in the courtroom, we're not going to be 30 minutes or less, which is true because you have to have, we've got 12 jurors and 24, let's do the math here really quickly. 12 jurors and 24 verdict forms. 12 times 24 is a lot. I'm not going to tell you how many because I can't think of it off the top of my head. We're close to 300, right? It would be 240 plus half of 240, or 288. Thank you. Did that in my head, Greeners. I hope you're right. Anyway, that's a lot of signatures. Let's see. Deanne B. Happy birthday, Mrs. R.A. 27 months. Deanne, thank you very much for 27 months. You are an OG. I think I'm a little bit giddy now. I've passed the point of tired. I'm at the point where I probably shouldn't drive tonight. But Mrs. R.A. did get a nap. She's driving on the date tonight. I will pay. She will drive. Let's see, JMR. I don't know why people are so interested in the Housewives of blank or Kardashians. I have not been into those shows ever. Maybe it's just it's not my demographic or something. All right. I do think, let's see, it's 5. My son should be landed at his destination by now, which is always good. So I think everything's good there. Get a taxi or a limo or something. Is Uber? I don't know. Here's what we've decided. We've decided that we're going to go out to eat tonight for her birthday. But we also have to celebrate her birthday another day because this has been a crappy birthday. And not just because I was working. That's not why. She's fine. She understands work. But waking up at 2-something in the morning and driving to the airport, sending a kid away to college, and then driving back, and then teaching homeschool, and then taking a kid to the doctor and coming back. It has not been a stellar birthday for her. So we're going to get some food, and then we're also going to call a Waymo. I don't think we have Waymos here. We have the robotic food delivery up around the college in Greenville, like the robots that will bring you your Chick-fil-A. That's it. CT versus Raul Valley has retained private counsel. Continued hearing. Continued until when? Do we know? March 25th, day after my birthday. Okay, so that'll be after Corey Richens. I need to send you an email with my special experience with Waymo. I'm worried. Just got another message. Hang on. Cow Josh, the pronunciation, the URL for the pronunciation of how to say that is like this long. That's crazy. Thank you, by the way, for the Facebook posts for my wife. I appreciate everyone who's giving her the happy birthday wishes over on Facebook. Susie, 64, member for 22 months. You are an OG. Happy birthday, Mrs. R.A. Such a cutie and so tolerant of our silly reindeer games. Kelly H., member for 12 months, says 1 year. What? Where does time go? This is the best law tube. Kelly H., thank you so much. Yeah, 12 months. It's been a blast, every bit of it. Wouldn't be the same without you here either. Kelly and Sherry and Max. March 24th is my brother's birthday. Well, you have a great brother if he's born on that day. That is my birthday as well. You cannot have another birthday. You are dragging us towards AARP too quickly. OG Wendy. This morning as we're driving, I think it was like probably 3:15 this morning. We're in the car, and it's pitch dark outside. And we're driving on the freeway, and it's foggy and dark and cold outside. We're driving, so I'm like, so happy birthday, saying to Mrs. Ari. She's like, thanks. And I said, how old are you? And we had to do the math. And by we, I mean she had to do the math. And I was waiting for her to finish because I know that right now, between her birthday and my birthday, we are the same age. And I don't know how old I am. And the math fails me. I'm not sure why. Seven's an addition. I just suck when it comes to that. And I was born in 1977. So I was waiting for her to tell me how old she was so that I would know how old I am. And, yeah, we figured it out. Let's see. Send you a shorter link. No, what is it? 34 minutes? Did they just run to the restroom? Are we expecting more people? I don't see Justin yet. I think they're talking about Angry Birds or Clash of Clans. Something on the phone. Who was it that says that they've never seen this defense attorney win a single case? Ooh, you had your golden birthday. 26 on the 26th. You only get one of those. May as well use those cushy chairs. It beats the bracelets they hand out afterwards if you don't win. I want to see a movie where the two of them are roommates. The attorney didn't win this one. The defendant did. No, I turn 26 every year. Josh says it was a bathroom break. I can see it. I'm a body language expert. He's a little nervous, I think. Nope, the cane just about fell. He caught it. Is he a body language or a potty language expert? They do seem a little bit more relaxed. Celebrate the second anniversary of half my age every year. The second anniversary of half my... Hippie Mimi, you lost me. That's higher math. That's like algebra. To celebrate the anniversary of your 29th birthday. The fact the defense is here, I think they think this is going to be a quick verdict. And in their favor. I sense confidence there. How you doing? I think they've got at least one juror who's firmly in their pocket. I mean, not like financially, but... I'm like, nah. The defendant works at a law firm, so he probably can carry on a conversation with the lawyer quite comfortably and understand the terms and the intricacies of that lifestyle. I take it he did well on the stand. He did. It was worth going back and watching. It happened, I think, right after lunch. Or, no, it was right before lunch. Stacy NYC, member for 10 months. You've been here longer than that. On the jury. Can you sum this case up? I missed it. Pretty please. Okay, so the defendant is actually a local there in Ohio. Works at a law firm. And on the side, he took a job with the company he'd worked for in the past. This company was called AMT, Advanced Micro Targeting. And no, this is not like a laser hair removal, as the name might suggest. This is a company that does paid petition gathering, paid signature gathering for referendums to get an initiative on the ballot, right? Because there are two ways something can end up on the ballot, really, in most states. And that is that your legislature says, hey, we're not sure if we're going to do this right. We think we should vote and let the people decide. Should we have mass transit built in downtown? You know, they might put it out for a vote. Or the people can say, hey, we want the legislature to do it, and they won't do it. So we're going to basically override and force the issue to be on the ballot. And all we have to do is gather enough signatures of people who say, yeah, we want it on the ballot. Usually it's about 10% of the number of people who voted in the gubernatorial election, so the governor, the previous election cycle. And then if they get those signatures and they're valid, it's on the issue. Well, they had an issue going on where a wealthy individual whose name shall not be named was not happy with what they call gerrymandering, which is the redistricting of the boundaries. It's when they redraw who's in what district, and if you do it the right way, you can pretty much pick what the results are going to be. Okay, so yeah, I know we're not pickles over politics here, but if the Republicans are drawing the lines, they're going to draw lines that favor them. And generally, the Democrats would want to draw lines that would favor the Democrats. And you can do that by taking if there's an area that's really strongly one side, you can divide it up into 3 different districts and spread it out amongst areas that are, usually the other side. And then you've split it up. So instead of having a district that involves just that area that always goes one way, now it goes the other way. That's gerrymandering. So there's an initiative with this guy. Oh, we know it's a rich guy that wants to have this on the ballot, and so he pays a company, AMT, to hire workers to go out and get signatures. OG Wendy, MD, welcome to the gallery. Thank you very much. You are an OG. So they hire a bunch of people. They hire Boots. Boots calls Mr. X. Mr. X has worked for AMT in the past. In the past, he was working for them, and they got mad at him, and they agreed to just mutually walk away from each other because he was accused of forging signatures, like faking the names and signatures on this referendum. Because for a signature to count, it has to be someone who lives in the county, who's registered to vote, and the signature has to match the signature on file with their voter registration. So he's like, you want to hire me? Last time things went south. And they're like, oh, no, it's in the past. Water under the bridge. No worries. Nothing came of that. It was fine. And he's like, all right. So he goes out and he collects signatures. And lo and behold, they fail the check. When the signatures get sent into the state and then back to the county, and the county starts looking at the signatures, like, whoa, these don't match. And one of the names happens to be the sheriff of the county. And so the people are like, hey, sheriff, saw your name on here, and did you sign this? And he said, no, I did not sign that. And they dug a little bit more. They got 12 people on this list. There may have been more, but 12 people who say, I definitely did not sign that. And that's not my signature. And so those names were all collected on sheets that were under his control. Thank you, Bree, for the recap. So Mr. X and Mr. Boots get together to put a question on the ballot, and they have an initiative that they circulate. And then they look at the computer afterwards to see if the signature matches, and there were 12 people that were questionable, and so they're like, well, who signed them? And so they do an investigation, and the police officer Says we think it's Mr. X is lying and oh man, this is tough, Bree. And so they talked to the people. The people say no, they didn't sign. So went to court, and the judge is going to decide. Yeah, okay. So that's basically the case. And Mr. X took the stand in his own defense, and he did a really good job, like really good. And I think the state has not proven, first of all, that Mr. X, they definitely did not prove that he wrote them, that he did it. And we did see, we almost didn't get, I would say we almost got in trouble for this because a lot of personal information was shown on the screen. And so the judge stopped showing that. But we were seeing people's names and addresses and signatures and then comparing it to how the name and address and signature looked like on the initiative, on the signature gathering form. And there was a lot of different handwriting, but there were a lot of signatures that just didn't match. And personally, I think that it's very likely that this was organized by someone, possibly not Mr. X, but by somebody to make sure they collected a bunch of signatures. And the only person who really stands to benefit financially for that is Boots. I'm not sure if he did anything, but he does have he gets a bonus. It's possible that people were sent there with names and addresses that they should write down. And they basically were fake people to be introduced to real signature gatherers. And that's a possibility. That's a reasonable suspicion in my mind. So, let's see. Used to audit for a very large cable company. We had direct sales rep selling accounts and receiving commission on homes that had been burnt to the ground a decade before. Did a lot of clawbacks. Oh my goodness. Follow the money. Yeah. Defense attorney is thinking about dinner. As am I. Let's see. Mr. X came off as totally honest and believable. His boss did not. His boss, and the part that threw me off was when his boss said, I've got 40 people gathering signatures for me. 40. That's 40. And at the end of the day, we gather up all their papers, all their ballots, their forms where they gathered signatures, and I review them, each one, every day. And then they sign everything and authenticate. We just do the precursory check or a cursory check. Not sure which one that is. And he says, it's really quick. It only takes about an hour, just 10 minutes each. Stop. Wait. 40 people, 10 minutes each is 400 minutes. And he says he does it in an hour. That's like 7 hours. That's a full day's work if it's 10 minutes each. And that's when I knew that something wasn't adding up. Something wasn't right. One membership from me for every forgery count that gets a guilty verdict, says Josh. Now we need somebody to bet the other way as well. That way the channel wins either way. I'm going to reference this case next time I get the knock on my door to sign a petition. Bree, what's funny is when I've had people knock on my door before, and this is a really common argument that I did not hear Mr. X give. He was looking for people who agreed with him, who say, hey, we want this change. We want this on the ballot. It's got the issue on the ballot. A lot of times a referendum or a signature gathering petition like this, the argument would be, if you have a strong opinion on this, you should sign this petition. Because if you think it should stay, you should let your voice be heard. And if you think it should go, you should let your voice be heard. You should have a say in this. That's the argument a lot of times the petition people would come around and give. They're like, we don't, it's not whether you agree with one side or the other. It's if you have a strong opinion, you should get to say it, and you should get your vote to count. That generally gets a lot more signatures that way. I'm not signing any more petitions. If I do, I'm using a fancy doctor's signature. All right, I don't answer my door. Mix up 1 hour and 1 day all the time. Yeah, especially when you do it every day at the end of the day. I've never had a petitioner seem unbiased. They always try to affect the change of some sort. Oh, yeah. Oh, yeah. They generally are not very good at hiding where they stand on that. Don't tell me to let my voice be heard. You'll be deafened by my scream. Noel has questioned John Hancock's signature on the Declaration. I don't know. What is that? Give me liberty or give me death? I don't answer poll calls either. If I do, I mess with them. Red Pen, I don't do polls unless they pay me for my opinion. And here's my reasoning. Someone's getting paid to gather this information. Or someone is benefiting financially or personally from my information. It's worth something to someone. YouTube values my opinion, and they'll pay me $75 for a half-hour poll that I can get done in 15 minutes online. I like that. They're not common enough. I don't get enough of them, but every couple months I'll get one. It's usually a good rule of thumb not to sign petitions in front of Walmart. Only sign petitions you know the issue and trust the petition to be accurately stated. Groovy Cheryl, I agree, mostly because the odds of your stuff being stolen from you while you're signing the petition are much higher as you're distracted with, how do I sign my name on this paper? I have 4 cameras watching the front of my house. If I answer the door, it's because I know who it is. Ace King says, I do polls on this channel. Never been paid. There we go. How do you get those surveys? I joined as a YouTube content creator, so I'm a partner with YouTube in that, and they asked me if I'd be interested, and through an email to provide information that would help influence how YouTube changes and makes decisions going forward. And I said yes, and they just included me ever since. Okay. All right. I have to go to the store. Okay. So now we have to make a decision. At what point do we say I'll save whatever happens in court. We'll record it and we'll watch it later. And when do I just go and start celebrating my wife's birthday? Next trial footage, Walmart footage will be the defendant signing a petition after visiting the murder aisle. Is it time for an Allen charge? Shake up the jury. No, I think they can do it on this one. Go now, says Francis Fitzgerald. 4:30. I think 4:30 is a good number. Where are you streaming if you don't mind? We are watching, this is a Warren County Common Pleas Court in Warren County, Ohio. They have a YouTube page that provides this to the public as they provide it to us. So you can watch this on YouTube directly from the court's channel. Fun thing about this channel, you can never go back and see what you missed. They live stream 24 hours a day, and because of that, YouTube doesn't save what happened in the past. It's a 24-hour loop. You'll see the cleaners come in and clean at night. The courtroom just stays live 24/7. Anything that happens, it's here. So we have to capture that. That's what we have HyperDecks for. Cool little recorder devices that allow us to preserve something for later. So if you look over here on my desk, I do actually have a HyperDeck right here that is recording. This is the screen, but it's recording right here on this drive, and it has another, see how much more it can record. This drive has room for another 14 hours of video, so pretty sure we're gonna get that. 24 hours a day. Alternative to hiring security guard? Yes. The only downside is they don't know how to start it if there's a power outage. And sometimes when the power does go out, the court has a YouTube outage for a little while. Watch that channel when I can't sleep. When I can't sleep, I usually watch gamers play video games, honestly. There's a couple. There's actually, you might find this funny. There's a guy up in Canada who is probably about half my age, who plays video games. But when he plays video games, he constantly just pontificates about his views on the world. So it's sometimes mixed with weird politics and personal opinion and everything else. And he doesn't hold back at all. But he's fun to listen to. So I generally will listen to him at night. So he gets my YouTube Prime money. Or YouTube Premier money. Premium. All right. Red Pen said go and Redwood babysit chat. I just don't know. I guess technically we could just leave it up and running. But West Wing is an excellent sleep show. Amber's putting up the finisher. Red Pen says, I did not say that. I did not. Okay, well, we're talking about YouTube, and because I'm still a little bit giddy and sleepy and saying things I probably shouldn't, let me tell you my favorite channels to watch on YouTube. Okay. These are the channels that I watch that release a video every week, and I watch every single one of them. The first one is Luke McFadden. He's a young kid. Well, he's married. He's got a kid now. But he is a crabber out of Maryland. So he goes out in the Chesapeake Bay, and he catches blue crabs, and he sells them at a roadside stand, and he sells them to restaurants. And now he has chips. Like, he has a line of chips and seasonings you can get at, like, a bunch of different stores. He's the crab guy. The guy is hilarious. He's always piecing something together out of trash to make it work, because he's like, every tool he has that's not a hammer, he calls a hammer, because he uses every tool he has as a hammer. But he's funny. He's really funny and a lot of fun. Just hardworking, really hardworking kid, and very charming. And he looks like a baby. He's the dimples, the freckles, you name it. Anyway. So that is that guy. And then you've got the version of him that's like the big brother, who is Jacob Knowles. And Jacob Knowles is a lobster fisherman out of Maine. Jacob Knowles is building a massive, massive boat right now. They're actually both building new boats for this next season. One's a crab boat, the other's a lobster boat. The lobster boat is huge. It's just like top of the line, best of ever. It's like it fills the entire boat building warehouse. Jacob's a lot of fun, and he's got a crazy crew as well. So I watch them every single week. Now, I've never eaten blue crab ever in my life. I've just barely tried lobster this year. Well, last year was my first time. This other channel I watch is a couple that do just crazy ideas, and they are called Ambition Strikes. Ambition Strikes is a husband-wife couple that they started just doing like, hey, this would be a fun project to document. And their channel took off. It's massive now. It's huge. And now full-time they do these projects. They took a Navy barge and converted it to a houseboat. And they just bought a boat down in Florida and drove up to Idaho, and they're completely retrofitting it. They're going to take it up the passage up by Alaska. Just amazing people. All of them do building. I don't know why I like to watch other people build so much, but I don't like building very much at all, and maybe that's why it makes me happy. So those are the three. I can't think of anybody else that I watch. Oh, Arms Family Homestead. I watch them, which is not so much building as much as just how they run their business and YouTube in general, and just a family. So you need to watch How Ridiculous. I love their stuff. They're amazing. Especially in their early days, throwing stuff off that huge tower. Before they started going to like Switzerland and throwing things off the dam, I liked their early days of using that little that little tower that had the terrible flies everywhere, and they were constantly, it was that was just pure YouTube goodness. Luke McFadden, Ambition Strikes, Arms Family Homestead, they're good, and then Jacob Knowles as well, Denisha. So, Homeschool Ground Zero. I should probably plug my wife's channel, right? She hasn't done anything for a while. My dad watches a woman in the jungle with a dog and a monkey on YouTube. Is that a thing, JMR? Is that a thing? What about the lawyer who took a break to make outdoor movie videos? Are you talking about the Outdoor Boys? I liked watching their stuff. It always gets me super nervous. They're like, we're going to send our 12-year-old out camping for 4 days in the Alaskan outback by himself. And if he has a problem, he can push this button, and within 24 hours, we'll be notified by satellite. Yeah, that scares me a little bit, but that was fun. You watched Little Man in the Corner. I can vouch for that channel. I think they have good intent, not the best content, but good intent. Thank you, appreciate that, Lee. My mom watches the birds on TikTok lives in the mornings. I have done that a time or two. If I had a cat, I would have a TV with the birds on 24/7. Like if I had an indoor cat. All right, it's time. It's 4:20. Well, it's 4:22. I didn't mean to say that, but we're an hour into deliberation. I will save. Actually, what I'm going to do is I'm going to stop the recording and start it again so we know what we haven't aired and what we have. I will save what's going on right here. We're going to go. Kiki's Garden says, I love this community. It has helped me in a lot of ways. I'm over here trying to reach 250 subs. Kiki's Garden. Love that you have garden videos. And keep it up. Keep it up. It's going to happen. How close are you right now? Let me check, Kiki. I know I'm one of your subs. So. Oh, you're really close. You only need 24 more. That's awesome. So, Kiki D needs 24 more subs to reach 250. OG says, I'll sub if you put the link. There's the link. All right. With that, it's been over an hour. We're going to go ahead and wrap up for the night. We're going to follow the verdict when it comes in. We just might do it tomorrow morning. Because it's my wife's birthday, and I want to celebrate it with her. Because it sure sucked just dropping off my kid at the airport. I mean, it was nice going there, but that's not a birthday celebration. It's not what you do to celebrate a birthday. Kiki's Garden needs one more sub and it'd be at 250. One more. At 251. Kiki D, you made it! Congratulations! It's time for a party. Let's see if we can do this. There you go. Tonight when you go home, please hug the people you love, smile at someone to make their day just a little bit better, and please stay safe till we go live again. Tomorrow morning, we'll catch the ending of this one. I'm recording it. You're not going to miss anything. We'll get the verdict. If it comes in tonight, it might not. I'm going to go out to dinner with my wife and maybe get her a present. Because I need to do that. So, you guys have a wonderful day. Thank you very much. It was wonderful spending it with you. I'm sorry I was so sleepy and a little bit giddy. I'll get plenty of rest tonight. I promise. So, I think that's it. You guys be good to each other. We'll see you in the morning. Bye-bye.
Happy birthday. You look good.
Hello?